right, we're going to go ahead and get started. Today's presenter is Trudy Morgan from, Morgan Thieler. Wow. Sorry about that.
Okay.
And she has been the managing partner for 15 years, but recently relinquished that. That very, I guess, large undertaking. So she's kind of happy with that move, but pleased to be there and focusing on the areas of estate administration, probate, trust administration, estate planning, and adoption. Kind of one of her specialty areas of focus is farm and business succession planning. And Trudy is originally from a farm near Hoven, is that right? Hoven, South Dakota. She attended undergraduate or earned her undergraduate degree here at USD and then went to law school at Ohio State University. Trudy and her husband have 3 children, 2 boys who, one that I just learned is an Eagle Scout and studying or in college in Nebraska. One is a 17-year-old soon-to-be Eagle Scout, and as a mom, I know how much work that is to be an Eagle Scout, so that's like major accomplishment. And then a 7-year-old daughter, who I'm sure brings a lot of joy and happiness to your life. So we are very happy to have Trudy here to speak to us today on the subject of estate administration. So I'll turn the time over to her.
Great. Thank you all. Yes, my youngest changed the entire household when she was old enough to start putting bling on her older brother's math homework. And when you're in junior high, that's a little embarrassing. So I like to think that she's helped us all become better characters. So yes, thank you very much for inviting me here. Actually, even though I graduated from Ohio State Law School, my husband was teaching in Mitchell at the time, and we both knew that we wanted to end up in South Dakota, and so we decided that I would spend a visiting year here at USD. And so I actually was in this classroom taking criminal law and criminal procedure because that wasn't a required class at Ohio State, and I figured if I ended up in Mitchell that might be something I would need to know. But I also had the opportunity to take estates and wills class from Professor English, who was here as a visiting professor during that time frame, and he was working with the South Dakota legislature when they were adopting the Uniform Probate Code. And at the time when I was taking the class, I was taking it because I thought it was something that I should probably know, but I didn't think that I would love doing estate planning and probate and trust administration. I really thought that I would love being a trial lawyer. And since I hated tax class when I was at Ohio State, I figured that I would end up doing anything but. When I started at Morgan Thieler Law Firm, they needed somebody to figure out the Uniform Probate Code because it had just been adopted. And so as the new associate, that was my role. I was to learn the process and understand the forms. And really what happened then is I learned the old probate code and I learned the new probate code because we were still completing probates under the old code and starting new probates under the new code. Let me tell you, learning how to do the post-death administration first before a person does estate planning is really a great way to learn how to do estate planning, because now after you've done the post-death administration, you understand how the documents that you're drafting as an estate planner are being implemented after somebody passes away. And I quickly learned how to do the federal estate tax returns, and back then South Dakota still had an inheritance tax and an estate tax. So I learned how to do all of those as well. And it's been really helpful for me to know some of those things because some of our neighboring states still have inheritance tax or estate tax. So all of those experiences, I think, really helped me in my future practice years. So I'm excited for you as you graduate and you go out and experience in all areas of the law. I'm a living proof. You just never know what area of the law you may end up practicing in. I want to start with really quickly doing the chart. I think I'm doing the clicker right there. This chart, and I created this after my experience last year. I found that a lot of the students had a difficult time using my outline to process through when an asset was subject to probate and when it wasn't. So I tried to use this for you to pull out and use as a model when you're trying to answer the questions and decide when something would be subject to probate and when something wouldn't. So the easiest way to explain whether something's subject to probate or not is that if I die and all I have solely in my own name is an asset or more that has no beneficiary designation, it doesn't say pay on death, it doesn't have a co-owner, and it is either land or it is another asset that is worth more than $50,000. If it is not land and it is worth less than $50,000 all total, so assets all in my own name solely with no beneficiary, no joint owner, then we can use the affidavit of small estates. But this chart will kind of help you flow it through as you're working through the problems, I'm hoping. When we encounter our first probate administration, some of the preliminary decisions that we need to make are, where did the decedent pass away? Where did they live at the time of their death? And where, if there's land, is the land located? Because all of those questions will help us decide where the proper venue, which county the probate needs to be completed in. So if I am a resident of Mitchell-Davison County and that's where I own my land, quite evidently that's where we're going to have to do the probate administration. If I'm a resident of Mitchell-Davison County but I own land in another county, we could do the probate administration in Davison County. That's usually where we do it, in the county of residence. But if I really don't own any assets located in Mitchell, in Davison County, and maybe I own land in a neighboring county, then perhaps we will choose to do the probate administration in the county where the land resides. Oops. So back summarizing, the post-death administration documents that we choose to use will depend upon how the asset's titled. So determining what type of asset it is and how it's titled will help you determine what type of administration tools you need to use. If the asset is in the decedent's name alone, then it's probably a probate asset. If it's held with one or more individuals as a joint tenant with right of survivorships, types of ownership, in that case, then we will use a different type of document called an affidavit to terminate joint tenancy. Many times, if it is a non-land asset, you won't need that type of an affidavit. In fact, I never use that to terminate joint tenancy in an asset unless it's real estate. If the asset transfers to a beneficiary as a result of a beneficiary designation or some type of a contract, so for example, life insurance, typically there is a beneficiary designation. A retirement type of account, typically there are beneficiaries designated, or a pay on death or transfer on death designation. Life estates, typically life estate is associated with land. A life estate is formed when I transfer the land to somebody else and retain the possessory rights during my lifetime. And I always tell people you have to think about how this worked in England to understand how this translated over into the United States. In England, the king owned the land, and he would grant his loyal knights the right to live on the land and collect the rents from it for as long as the knight was alive. And then upon the day that the knight passed away, the land belonged to the king again. It reverted back. Well, in the United States, the way we use life estates is sort of the reverse effect. So if I retain a life estate, what's happened is that I have made my kids king. I have transferred the land to them, and I have reserved the right to use it, collect the rents from it, dance a little jig on it, whatever I want to, as long as I'm not harming the land. And then upon the day I die, it's already vested. My children already own it. The other type of document that will govern what needs to be done will be if there is a trust and if the trust holds title to assets, in which case a trust administration would be completed rather than a probate administration. If it is a joint asset, the affidavit of terminating joint tenancy would be required to be recorded at the Register of Deeds office where the land is located. And if it is a life estate in the land, when I pass away, it's easier to talk about me dying than any of my clients or any of you. So if I were to pass away and I hold a life estate in an asset, then when I pass away, an affidavit, a sworn statement that gives a little bit of biographical information about me and the person who or persons who own the remainder interest is recorded along with the fact that I've passed away. And that will, quote unquote, terminate my life estate, or as my clients say, how do we take mom's name off the property? That's how it's done. So there is another process or other processes to terminate joint tenancy or life estates that involve an application to the court and a request for an order terminating those interests. Those processes were used when we had the state inheritance tax format because we had to verify that if there were an inheritance tax to be paid, that it was paid and that was released as a potential lien against the property. But typically we don't need to use that process anymore, so you'll see in your materials when we get there that you're receiving from me a form called Affidavit to Terminate Joint Tenancy or Affidavit to Terminate Life Estate, because that's the form you would use. When we completed administration, we also need to help the beneficiaries or the heirs determine what the value of those assets were at the time that the person passed away. So again, if I were to pass away and I were to own land, I maybe have a house, maybe have some livestock, maybe have some equipment, those types of assets. We have to put a value on those assets for a number of reasons, but one of the main reasons is because we receive what's called a step up in basis in some of those items. So as an example, if I bought a quarter of farm ground for $100 an acre back in 1999, and now at the time that I pass away, it's worth $5,000 per acre, my purchase price in that property as a tax basis goes away. So backing up a step, during my lifetime, if I have purchased this ground at $100 per acre and I sell it for $5,000 an acre, I will pay a capital gains tax on the difference between what I bought it for and what I sold it for. It's an income tax on the gain. If I die owning that property and it's worth $5,000 an acre, that is the new basis. So when we transfer that asset to my kids, they now have a tax basis of $5,000 an acre rather than my purchase price basis of $100 an acre. So if they sell it 5 years later for $5,500 an acre, they will pay tax on the difference between my date of death value and the later sale price, not my purchase price and the later sale price. So determining what the value of those assets are at the time somebody passes away is necessary because the beneficiaries or the heirs will need to know what their tax basis in that property is. And in a lot of cases it's required if we're doing a probate administration because we have to have a report to the beneficiaries that identifies on an inventory what the assets of the decedent were and what they were worth at the time of death. The other assets that are really important to sometimes get a date of death value for would be livestock and equipment, because if I own equipment, let's say, that I have completely depreciated out on my income tax return, or if again I purchase livestock at $100 a calf and now it's worth $1,800 a heifer or a steer, whatever that new basis is, if they take that critter to the sale barn and sell it at that $1,800 per critter, they will not pay tax on the difference between my purchase price and the sale price, you see. So for income tax purposes, it's a huge piece of information that the heirs need to know. Also, let's say I have a combine that I purchased 5 years ago for $300,000 and I depreciated it all the way out, but it's really still worth $100,000 when I die. Now my heir inherits it at $100,000 and redepreciates it. So valuing the assets is important both for administration purposes in many cases and also for income tax purposes, potentially also for estate tax purposes. If a person passes away and we've valued everything that they have, we are then in a position to determine whether or not they're required to file an estate tax return, and I'll talk a little bit more about that in a minute. If there are assets that have beneficiaries or joint owners titled on those assets, and they are financial assets or vehicles, that type of thing, bank accounts, life insurance, retirement accounts, many times the clients or the beneficiaries will need very little or no help from the attorney to get those accounts transferred. Oftentimes their financial advisors are very helpful. They show up at the financial advisor's office with a certified copy of the death certificate, and the financial advisor will help them fill in the documents that they need to transfer those assets to themselves. Oftentimes the financial advisors are very helpful also in cases where maybe it's a retirement style of account that has a lot of income tax issues built inside of it. The financial advisor will very often be in a good position to make recommendations to the beneficiary as to whether or not it would be good for them to cash it out, roll it into their own account, or stretch it over time based on their particular income tax situation. So they may or may not need a lot of assistance for the attorney on those accounts. However, if there is a trust agreement in place, there might be a few things that the attorney needs to assist with. There would not necessarily be a probate administration if all the assets are titled in trust. So as an example, let's say that I create the Trudy Morgan Trust. Trudy Morgan is the trustee or the manager of that trust during her lifetime, and in the document it says, when I pass away, my son is the new trustee of my trust. Well, after I pass away, we can't use my social security number anymore to report the income that this investment account or other assets are receiving because I'm not here. So whether we have a probated estate or a trust, a new tax identification number has to be applied for with the IRS. Also, I can't be the trustee anymore of this trust, obviously, because I'm no longer living. So the alternate trustee steps up and takes management responsibilities of the trust. The document that most financial institutions need in order to verify that this person is the new trustee is either giving them a full copy of the trust or what we call a certificate of trust, which is roughly a 2-page document that has the name of the trust, the date of the trust, the fact that I was the original trustee and now I'm deceased, and here's my son's name and address, he's the current trustee, and here's the new tax identification number for the trust, and it says whether he has any limitations, like if there's a limitation that says he can't sell land for 5 years, or he has to have an independent trustee sign a lease for the land if he's renting it, or something like that. If there's a limitation on him, then that would be stated right in the certificate of trust. And that would be signed in the presence of a notary, and then hopefully if he's a good, responsible trustee, he's off and running and he can do the required reports that he is to give to the beneficiaries, the inventory of the trust assets and accounting of the income and the expenses that he's required to give according to the trust document. And he may or may not need the services of an attorney to do that. Some trustees will hire the lawyer to do those documents. Many times they will do them in their own fashion, especially if they're a sophisticated trustee. I think I already skipped ahead and talked about the value of the asset for either income tax basis adjustment or determine if an estate tax return is needed. But I'm going to skip ahead a little bit. So, you know, you've probably heard the story about the 3 fellas who died and went to heaven, and St. Peter met them at the pearly gates, and St. Peter said, welcome, you know, before you enter the pearly gates, I just I'm just curious. I'd like to ask you each a question. So there was a teacher, there was a minister, and there was a lawyer, and he said to the teacher, you know, as the three of you stand here and you're looking down at the funeral today, what would you like to hear them say as they look over you in your coffin? And the teacher said, oh gosh, I really hope that they say that I was a good role model for my students, that I taught them skills of the classroom, but also skills of life. And I really hope they say that I was a good father and a good spouse. That's what I hope they say. And St. Peter said, well, that's fantastic. Come on in. So he turned to the minister and he said, what would you like to hear them say? Well, the minister said, oh, wow, well, I really hope that they are, as they're looking down upon me in my coffin, they say, he was a good man, he was a good shepherd of his flock, he really taught and lived the example of the moral character, he was compassionate, and as well as being administrative, he was pastoral, he was a good pastor. And St. Peter said, wonderfully said, come on in. So he turned to the lawyer and he said, well, as they're looking over your coffin, what would you like to hear them say? And the lawyer said, well, I hope somebody says, look, he's moving. You know, death is really a hard thing for us to think about. It's a really hard thing sometimes for clients to plan for, and sometimes it's a really hard area of practice for us to feel like we can be engaged in. But frankly, I think each of us will encounter the need of people to have our services in this area, the need to be compassionate, and if in cases where we choose not to practice exclusively in the area of probate and post-death administration, some of these smaller techniques are almost always going to be needed, even if you're a business attorney or a litigation attorney. So as an example, the Affidavit of Small Estates is a very simple, straightforward document that allows us to transfer assets if they are solely in the person's name, are not land, and are worth $50,000. Now, a couple of things to remember. All of the assets I die owning have to be less than $50,000. All of the assets that are solely in my name with no beneficiary nor no joint ownership have to be less than $50,000 and not land in order to use this affidavit. Okay? So as an example, if I have a checking account worth $20,000 that's joint with my spouse, and I have a small mom's mad money account at another bank just in my name with 500 bucks, and if I have a car that's in my child's name and my name, and it's worth $20,000, well, all total it might be worth more than 50, but the asset that's solely in my name with no beneficiary and no joint owner is the $500 account. That's the only one we're talking about, okay? That small estates affidavit is provided to the institution holding the asset, and the asset passes to the person named in the will or intestate succession without probate, meaning when the person, my family member probably, signs the document, they are saying that they will pay any claims and they will transfer to the asset to the person or persons who are entitled to receive it. And they will also let the Department of Social Services know, giving them a copy of it, because if the Department of Social Services has paid for my long-term care in a nursing home, they may want that asset and they need to be notified of that. So you'll see that right on the form. The other thing is there is a version of that statutory affidavit of small estates that you can find online through the Department of Motor Vehicles that you can use just for motor vehicles. Many times people will go to the courthouse, and in some of the more remote counties, the treasurer's office will have those. They just print them out and hand them to them, and then they go take care of it. But sometimes they don't, and they might come into your law office, and you will just go online and help them fill this out and take it down to the courthouse to transfer the vehicles.
If someone has minimal assets but they owe to the Department of Labor, they have to start
Good question. If there are minimal assets but there is a lien owed to the Department of Social Services for debt, for paying for my long-term care, technically there's supposed to be a probate administration. The problem then is if the debt exceeds the value of the asset, what we sometimes see is nobody wants to be the personal representative of the estate. Now, creditors can be the personal representative of the estate. And so what sometimes happens is, people don't know that there's a lien. And perhaps they didn't know that there was a lien, and especially with the vehicles, they take it in, they transfer the vehicle, and then somebody tries to chase them down and get the value of the vehicle that's maybe worth $2,000 and it's already spent. Well, I don't know that the Department of Social Services chases that too far, but we have had circumstances where we send the affidavit to the Department of Social Services because there's maybe $10,000 or $15,000 in some type of an account, and it's been a couple of years since the person passed away, and maybe it's located in the unclaimed property statute, and so we provide the affidavit, and all of a sudden the Department of Social Services says, time out, we want to snag that asset. And then sometimes what happens, because the bank or financial institution is released from any responsibility when they transfer that asset to the person, that's already occurred by the time the Department of Social Services gets a copy of this document in the mail. We have to call the person back and say, you know, that affidavit that we prepared for you and that cash that you took, hope you didn't spend it, because we just heard from the Department of Social Services. So technically, yes, if you know there's a lien, then you're not allowed to use this affidavit, and you're supposed to start a probate administration. Might be hard to find somebody who's willing to be the personal representative when, you know, they might get paid a little bit and the rest will go to the state of South Dakota. But that does happen. Good question. Probate is statutory, and I know that this makes me just a little bit geeky. But I really like probate because it's fairly methodical. It's very statutory. On the other hand, the interesting thing is, despite how well laid out it is in the code, and despite the fact that you can get the forms from the Bar Association of the State of South Dakota on their Dakota disc, despite the fact that you'd think it should be pretty easy to follow in these circumstances, there always seem to be unusual things that pop up that just don't quite fit within the nicely laid out 1, 2, 3, 4 sections of the code. And it's that part of it that always makes you say, is there a nutshell on this? But what I would say is, if this is an area of law that you intend to practice in quite regularly, you should just read that whole section of code. It's actually not that long, and it is really helpful if you've tabbed out some of the parts that you use pretty often. I'm not as electronic as I would like to be. I do tend to use a lot of electronic research. I do my own typing on my own forms sometimes. But I have found that there are certain things that are just easier if I have my state code book and I just have tabs to the sections and just pull it open. It's also easy for me when a client comes in and says, how are personal representative fees calculated? How do creditor claims work? Sometimes I just pull the book off the shelf, put it open, and put it right in front of them while I'm explaining it to them. So I would say read it all the way through, electronically or in the code book, whichever is easiest for you, but do read it. We are surrounded by a number of states who have adopted the Uniform Probate Code. Interestingly, when I was clerking for a law firm in Columbus when I was in law school, the firm that I clerked for did real estate, probate, and adoptions, and I did a little bit of probate as their clerk. I helped with a little bit of the filling out of the forms and that sort of thing, sort of their peon, minion. And I did all of their courthouse runs. And the interesting thing about the way South Dakota's Uniform Probate Code forms were adopted or implemented in the way Ohio's were adopted or implemented is that in Ohio, you don't vary the form. You almost at that point, it was like, not a typewriter because I'm not quite that much of a dinosaur. But it was sort of like that. You had to use exactly the form. They gave you the wording, and you have to like X through it on the computer. You couldn't vary the language at the time. You had to use that particular form. South Dakota, we have the forms. You can use them just the way they are, but you don't have to. You're not required to necessarily use the formatting that is in the Dakota Disc forms book. You do still have to have the required margins that you have to use when you file things at the courthouse, that sort of thing. Yes?
Time to a previous slide, you mentioned here with the various neighboring states adopting the UPC. To your knowledge, do they also have similar laws as to the amount for that shortcut that you were discussing earlier, the $50,000?
They're not very similar, but I shouldn't say that. They're similar in the sense that every state has sort of a minimum that they require. I can't recall what they are, but one of our neighboring states is like $75,000. Another one, I think, used to be 50 and moved up. I can't recall, so don't hold me to that. The interesting thing, though, is every state has modified or tweaked little pieces of it. You know, we all, especially in our part of the world, are fiercely independent, so we don't want to be just like somebody else. So every state has adopted a little tweak to it. One of the unique things, and we get this all the time, lawyers from other states call and they say, hey, there is a little lot, like my favorite was the lot on Lake Mitchell, which is a glorified lake, and it was maybe worth $2,000, this lot. So it was probably more expensive to do an administration of it than what the lot was worth. And the lawyer from out of state says to me, don't you have like an affidavit of small estates that we can use for this lot? And the answer is no, it's land. Really, are you sure? And I'm like, I've been doing this for a while. I'm pretty sure. Well, would you would you look that up in the code book for me and prove it to me? Like, well, I felt like I was back in law school and the professor was making me show my work. So there are a lot of other states that have adopted the Uniform Probate Code that have some sort of a shortcut procedure, a small estates affidavit that does work for land. We do not. So, but that was a good question. Oops, I'm a little touchy there, my little roller. I'm skipping ahead. The Uniform Probate Code assumes that the heirs do not automatically need the court's protection or direction, which is a little bit different than under the old probate code or the way the code exists in some states that don't have the Uniform Probate Code. For years, people were basically saying, gee whiz, if our whole family gets along just fine, why do we have to file the will at the courthouse, mail it to everybody, have a hearing, a public hearing at which the court says nobody showed up and therefore I am accepting the will into probate and I will sign this order saying that the executor, now we call him personal representative, has power to act. Why do we have to have this 2-week delay with public notice to everybody, et cetera, et cetera? Well, in the olden days, before most people were literate, they had readings of the will publicly. They'd bring everybody in and they would read the will out loud because people couldn't read it themselves. And then as people became literate, the idea was, well, we don't have to read it out loud to everybody, but we got to get it out there to everybody because they will all need to have, you know, an opportunity to read it, or there might be some people that can't read it themselves and may need to take it to somebody to read and may need to find time to object to it before the court admits it to probate. And the philosophy now is we'll admit the will to probate, meaning it will be filed at the courthouse assuming that it is properly executed in the state. The clerk, as an administrative role, can accept it into probate and sign the document called letters of personal representative that gives the personal representative authority to act. And then the attorney who is administering the estate has to send the will and the document saying that the personal representative has been appointed to all of the people who are named in the will and to anybody who would have inherited if there had been no will. So they, after the personal representative gets authority to act, still have an opportunity to come in and say, whoa, hang on, hold it, wait a minute, there shouldn't be a probate of that will because guess what, I have a newer one, or guess what, I think that the person who was named as the personal representative was twisting the arm and forcing them to sign a will they didn't really want to sign. I want to challenge it. So it doesn't prevent a challenge. What it does is it gets the process started right away, gets a copy to everybody, and then if they want to challenge it, they can still come in and challenge it. It's just that we can get the process started right away, informally. So the Uniform Probate Code assumes that the heirs don't automatically need the court's protection or direction. The devisees, the people named in the document, or the heirs, the people who would have inherited had there been no document, can ask the court for protection at any time up until the date that the court enters the final order if you formally close the estate, determining heirs and or beneficiaries. If the probate assets held by the decedent in their own name and there is no will, you will still need a probate. If there is a will and there are assets held in the decedent's own name, you will need a probate. So maybe say that again. If I die and there are assets solely in my own name with no beneficiary, no joint owner, and it's either land or it's worth more than $50,000, there will be a probate. If I have a will, that's the instruction booklet for the probate. If I have no will, there will still be a probate. It's just that the state of South Dakota has a will for me that has to be followed. Does that make sense? Oops. A little bit trigger happy. The probate forms were created basically by the people that are willing to be volunteers and do this, the Real Property Probate and Trust Law section of the state of South Dakota State Bar Association, and they're on Dakota Disc. You can, if you buy a subscription to Dakota Disc, you can, they're user friendly. You can type on them, copy and paste them, whatever you want to do with the language in them. There's also an index, and I copied the index in your appendix so you can see those. The forms are samples. They're not updated. But what I will tell you is that if you get the forms, there is also a very helpful little explanation that goes with every form that says use this form when, how to use this form if you use this form. And I will tell you, there are some times when I still pull those out and look at it and go, no, this is a really unusual circumstance. As I mentioned, the judge isn't necessarily involved in an informal probate opening, so if the will appears to be validly executed in the state of South Dakota, you can file it informally with a document that you prepare as the lawyer called an application for informal probate. And then you also prepare all the documents, by the way, that the clerk signs, because clerks can't prepare their own documents. Once those are filed and you get those documents with the file stamps on them, then you send the notice to all of the heirs and any interested person defined under the code, which would be the persons who would be entitled to inherit if there were no will, and in some cases creditors. There is also a process by which a person who believes they're interested in that probate can file a demand at the courthouse, so that if a probate starts, then the attorney has to send a copy of the documents that they're going to file before they file them, because the clerk can't accept them. And this happens a lot of times if, let's say, I'll just give you a true life story. We represented an estate where the decedent was in a car accident and the other party was injured. The other party involved in the car accident was injured and our person died. And so when we prepared the application for informal probate to file it at the courthouse, the other person's attorney had already filed a demand because they wanted to know if there was a probate being started, because once the probate started, they wanted to sue the estate. to get damages for their personal injuries. So if that's the case, then the clerk of courts will call you up and say, whoa, guess what? There's a demand for notice, so you are going to have to verify for me that you have sent a copy of all these documents to the person who's demanded notice before this gets filed. And that will happen every time you file something in that probate after that until they release their demand for notice. Every time you file anything at the courthouse after that, they get to see it before it's filed. Or what I do is I mail it out with my proof that I mailed it and send the proof with the documents that I'm filing. Oops, there we go. The clerk can deny an application for any reason, and I say smells bad. We're really fortunate. I will say we are very, very lucky because clerks in South Dakota they try very hard to keep their files clean and accurate. And so if there's something that isn't quite correct about the documents that have been prepared, they may call and say, hey, by the way, when you scan this in, I think you have another page. It just didn't make it here because now we have electronic filing now. Or they may say that you referred to an attached Exhibit A, but I don't see the Exhibit A. Was that inadvertently omitted? Could you get that sent to me? So a lot of times, rather than just reject it and you have no idea why, they're really good usually about calling you and say, hey, I'm going to reject this and here's why. And then you say, oh, well, let me get you my Exhibit A. And then they'll accept it. So most of the time, they really only reject it if they find that either, if it's not a properly signed will, it's not signed in the presence of two witnesses and a notary or whatever. But if there is a reason for a more formal proceeding, number one, I know that somebody's going to come in and contest this. So I might as well start it with giving everybody notice in a public hearing and let the judge admit it to probate after we've had our big brouhaha in court. Or perhaps it's a copy of the will. We've had this happen too. We can't find the original. The copy is in the safety deposit box. Heaven knows why they didn't put the original there, but they put the copy there. We can't find the original. Or there was a house fire. The original was burned up. It was inadvertently destroyed. I don't think the house burned up the will on purpose, or the person burned up the house and the will on purpose. Or if they did, they might have burned the house on purpose, but maybe not the will on purpose. So in that case, if you can show that the copy was inadvertently lost or destroyed, then it can be probated, but it won't be an informal probate. Then it does have to be a process by which the court admits it to probate. My other favorite is handwritten wills. Those typically cannot be informally probated. So we had a will on a napkin. We had to file the napkin and give a copy of the napkin to everybody and have a public hearing to admit the napkin will to probate. We have to wait 120 hours, 5 days. Most of you already can do that math in your head. I usually have to have somebody tell me how many hours is how many days. 5 days after a person passes away, I assume it's so that we know they're really deceased. So they're not showing up somewhere claiming that it was a mistake. Before we can file an application for informal probate, the application, again, doesn't require a hearing or notice unless the demand has been filed, and once the clerk grants the application, the personal representative sends the notice of admission of the will and appointment of personal representative within 14 days. The personal representative is represented by you, their trusted lawyer, so you are the one that's sending these copies. The notice also is sent to, the heirs and the beneficiaries, the devisees, the beneficiaries, and the State Department of Social Services, because again, if they've paid for any services, they may have a claim to file. Any interested person, so if we're aware either that there's a demand for notice or somebody has filed a tax lien, or we just know that there is a creditor out there somewhere, we will sometimes mail these documents along with a notice to the creditors of the administration. If we do the formal probate, you know, the number 14 is used throughout the probate code. It's a little bit different time frame than the normal civil procedure hearings. So lawyers who don't do a lot of probate sometimes accidentally use the shorter civil proceeding hearing time frame, but it's a 14-day notice in the probate administration. So if we're going to do a formal probate, we file the petition and we give copies 14 days before the hearing. After somebody's been appointed, informally or formally, the documents have been filed and we get the copies from the clerk. 14 days after that, we have to have mailed these notices. Not necessarily creditors. We have a little more time to do that with creditors. When to use a formal procedure? Again, if the will is lost or inadvertently destroyed and only a copy is available. If more than 3 years has passed since a person has passed away, then we're not allowed to do the informal process. There is a series of exceptions in there. If we're just confirming title to real estate, sometimes we can still use the informal process, but sometimes the clerk won't allow us to, even though we're just confirming title to real estate. Or if there's any other problem. Sometimes I know that there's somebody out there that's going to claim they have a will that's more recent, or that the will that we have that's more recent is going to be challenged, and we want to start that timetable ticking, so we go ahead and file it and give notice and have a hearing, and now we got to have the trial on the issue of the will up front and center before we start anything. So sometimes we'll do that. So first, make sure probate is needed. This happened to me once. We started probate, and guess what? The land that we thought was owned as tenants in common, because that's the deed we had in our file, the spouse had a half interest, and the deceased spouse had a half interest, and the surviving spouse had a half interest, and the last deed of record that was in our files did not say joint with right of survivorship. But lo and behold, they had hired a lawyer somewhere else after that and prepared a deed that said joint tenants with right of survivorship, and the kid had it in their possession and recorded it after they passed away. Had we called all the kids, we would have found that out, but we didn't, so we started a probate and didn't need it because there was a deed in the possession of one of the beneficiaries that they ordered them to record it if something happened to them. Go ahead.
What do you do if you have a probate that you have started, like once it's already?
Yeah, that's a good question. What do you do? Well, in our case, we said, oops, sorry, we'll refund the fee. You know, we want happy clients, because really you wouldn't, if somebody had told us, we wouldn't have done this. Actually, if the family had gotten along, we might have known, but since they didn't, the parent came in, hadn't spoken to it was a mess. Anyway, in that particular case, we just, you can leave it open indefinitely. Now, the clerk doesn't like that because they don't like open files, and so you either file a verified statement at the end, just confirming that the probate wasn't needed to transfer any assets, or you do a petition to complete the probate, and just explain that in the petition and have the judge sign the order releasing. So. Venue issues can happen when there's more than, the person could be a resident of more than one county based on the city they live in, or as I've found, that people can be a resident of Garrison, South Dakota, but they're really a resident of Minnesota because their address is South Dakota, but they're across the state line. And actually I have some clients that have a South Dakota address but live in Nebraska. Akron too. So just be careful about that, because you could find that the person is actually not a resident of our state at all, although they may still need a probate here if they own assets here, as an example. But the venue might be different depending on what county they're considered to reside in, or if there is a probate administration started in Iowa, for example, then the South Dakota proceeding will be what we call ancillary, which means that you would take a copy of the documents filed in Iowa which appointed the personal representative and attach them to the application here saying this person has already been appointed there. Therefore, they have priority to be appointed here. So because you have to state in your application for probate whether or not there's a probate happening somewhere else, whether there's a personal representative that's been appointed somewhere else. So asking those questions is helpful. And then if there's no will, then we have to find out who the heirs and the personal representative, who all the heirs are and who has priority under the state law to be the personal representative. And if in some cases you have more than one person that all have equal levels of priority, then you need to have them either duke it out, step outside and arm wrestle, flip a coin, or you have to have the court decide. So in the case where you have 3 or 4 kids, let's say, and the parent passes away and they haven't chosen who's going to be their personal representative, all the kids have equal right. It doesn't matter that one says they're the oldest and one says they're the smartest and one says they're the favorite. Doesn't matter. We have to decide which one's going to be the personal representative. You can have more than one, but if you have 10 kids, they're probably not all going to get appointed. And so the easiest way is if all of the ones who don't care to be the personal representative sign a renunciation and nomination, meaning I renounce, I don't want to be the personal representative, and I nominate my favorite sibling, John. And then also in that document, you can have a separate document, but we usually put it all in one. We suggest that they waive the requirement that the personal representative be bonded, sort of paying the insurance premium to make sure they don't abscond with the asset. So if everybody's confident that their sibling isn't going to take off with the money and doesn't need to be bonded, then we just put all that in the same waiver. The clerk of courts has to determine in the document that all the people who have an equal or prior right to be the personal representative have waived. We actually have a situation where the decedent owned land in South Dakota but lived in New Mexico. And in New Mexico, everything was probably upside down. And she had no kids, no spouse, no living parents, so it was just her siblings. And they didn't really want to go to New Mexico to be the personal representative in New Mexico. And so we had all the persons with prior right to be personal representative waive their right, renounce, nominate, and appoint a lawyer in New Mexico to be the personal representative. And then he was also appointed as the personal representative in South Dakota too. But the common mistakes are some of the things that it's just easy to forget about is failing to list all the heirs, or incorrectly only naming the people in the will, because sometimes people will leave people out. Or this always was really hard for me. So we had a couple lawyers in our firm that didn't really do a lot of estate planning or probate, but they had, sometimes people come in and want to do a very, very simple will, which is no problem, but sometimes the person was a single person, had no spouse, had no kids, and they just wanted to name their charity, which is great. So they did a will that says all the charity when I pass away, and here's the bank that I want to be the personal representative. So then what happens is they pass away, and we're required by law when we probate that will to give notice to the devotee, the charity, and to their heirs. Only problem is we don't know who they are. I don't know who their siblings are. I don't know who their nieces and nephews are. I don't know where they live. And so now we have to try to track them down either through a paid service, or we have to publish notice to the heirs. So in the case where we know who somebody's relatives are documented in the file, because someday if you have to do the probate administration, you might need to know who these people are, and some addresses, just so if you find one, they might know where the rest of them are. I find that he shall remain nameless, but we had the hero law clerk one summer. This happened where the person, when she passed away, she had no kids, she had some nieces and nephews, and she named them all specifically, but she had this one young man who didn't have a family to speak of, and he stayed at her house to finish high school when his family moved away, and he didn't want to move with them. They had one more year of high school, and then he came back in the summers during college and worked in this small town. And then Fast forward 25 years, she passes away and she leaves him a specific bequest in her will, but he's not related to any of these nieces and nephews, any of the family members. So we have the wonder clerk, we called him, because there wasn't anything he could not find out. And so he took a trip down to this little town high school, and he looked at the pictures from the class that this guy would have graduated from, and it's a small town, and so he located the names of some of the other guys in the class, and he called around, and turns out one of the guys was working at a local radio station and was his friend on Facebook, so we were able to locate the fella. So having given you a true life story, just remember, document those files with connections so you can find these people. If there is by the way, if you have a will that says when I die, whatever I have, put it in my trust, and this happens occasionally, somebody sets up this beautiful trust and they title everything dutifully in the name of their trust, so when they pass away there shouldn't have to be a probate, and lo and behold, I had a client who inherited something from his brother, didn't expect to inherit a piece of land from his brother, but before his brother's probate estate was done, he died. And so once his brother's probate was done, now there's this piece of land that's titled solely in his name. And of course, even though he has this lovely trust, we have to do a probate to transfer the land to his trust. And he has this very simple will that says, if I own anything solely in my own name, probate it and dump it into my trust, which we do. So when you have a circumstance like that, the beneficiary is the trust, okay? The heirs are not necessarily the beneficiaries of the trust. The heirs are the people who would have inherited if there wasn't a will. You see what I'm saying? So in this case, he had a surviving spouse. State of South Dakota says if you have a spouse and they did not have kids before the marriage, I, the decedent, had no kids before I married this person, and they're my surviving spouse, they are my sole heir. So my spouse would be named in that case, and the trustee of the trust is the beneficiary, not the beneficiaries of the trust. You see what I'm saying? I don't list on my application and give notice of probate to the beneficiaries of the trust. I list the trustee of the trust, because that's who the beneficiary is, and the spouse. Okay? The court can grant a petition for supervised administration even after you've opened it informally. You can switch to a more formal administration and ask the court to supervise the work that the personal representative is doing, or even just one or two actions of the personal representative. So, for example, in some cases, we may want to ask the court to approve the sale of an asset and the value of the sale, or the person to whom we're selling the asset to, so that if anybody has a problem with that, they can come in and object before we get the sale done. This can happen a lot of times with family land. So if the land is, let's say, being sold to a nephew who's farming, and perhaps it's for appraised value, we've gone out and we've hired an appraiser who puts a ballpark number that they believe is true market value, and the personal representative wants to offer it to the nephew rather than put it up for public auction. Sometimes it's a good idea to have the court approve that if we think that there might be kids that might have a beef with that. Now, if we're pretty sure there's no damage, meaning if we're pretty sure that that appraised value is probably high market value, then if somebody comes in later and says, gee, it shouldn't have been sold by private agreement to this nephew for the appraised value, because if you would have sold it by auction, it would have gotten a larger value. Well, if we're pretty sure it wouldn't, then sometimes it's okay, or we're pretty sure nobody would object, then sometimes it's okay. But sometimes it's a good idea to have the court, quote unquote, bless that at a hearing after there's been notice to people so they have an opportunity to object, depending on the circumstances. So again, it's not a requirement, because the personal representative can sell for market value, reasonable value. I'm just suggesting sometimes you may want that approved by a court after notice. Or somebody will come in and say, hey, I think the personal representative took money. Ooh. So maybe they want to ask the judge to do an intermediate report, review of a report from the personal representative to see what came in and what got spent before the end of the administration. letters of personal representative, I think I mentioned this before, this is the document the clerk signs, or if it's a formal administration, you're having a hearing first, the judge signs. It's really, it seems anticlimactic because it's this sheet of paper with maybe 3 sentences on it that says this person has power to act. But I'll tell you, it is the gold seal. It means that the personal representative can sign the decedent's name for anything, pretty much. And that's what they need. And if they come into your office saying, the FSA office says I have to have letters of personal representative, what they don't understand is the FSA office is telling them they have to go get a probate, and you have to break the bad news to them that now this is not a signed statement that I can just hand you. This is a court process.
Even the post office.
That can happen. Yeah, that can happen. The post office might require copies, certified copies of the letters of personal representative in order to forward mail. Right. Because obviously, if I have a check coming in from my credit card reward, I'm waiting for it, and I kick the bucket before it comes in, and somebody says forward all the mail to this address, well, they're going to want to know how that person has authority to start collecting my mail that might have some money coming into me. So there, I mean, it seems a little ridiculous, but that can happen. What a lot of times happens is if the person isn't in an apartment, for example, if they have a house and the house isn't going to be sold for a while, they don't even bother, you know, to forward the mail. They just let it keep coming to the house. If the house is joint or whatever. But yeah, I mean, that can be a problem too. And then it's sort of gosh, do we have to pay the cost of a probate administration for, and then the same is true for the FSA office. I mean, I get it. A number of years ago, the federal government took a beating in the press because everybody, including Reader's Digest, was claiming that the government was paying dead people for crop payments. Well, in reality, it wasn't like somebody died and we put them in the freezer and now we're cashing their social security checks for years. That wasn't the case. What was happening is sometimes somebody passed away and the estate kept farming that year, or the farm program payments are 2 years behind. So somebody passes away and we got to go collect the payments that the government owes them for the 2 years before this, for 14 and 15, even though they died in 16. But that's not how it looked. And so the FSA office couldn't just pay the surviving spouse, couldn't just pay the kid that's on the farm those remaining program payments. They had to actually get appointed as the personal representative of the estate to get those payments in some cases. So just had one of those phone calls last week. The spouse was not happy. And she said, well, if I vote for Trump, will that fix it? And I said, no. Well, I called Christy Nolan's office. I know, but I don't really know if there's any solution to vote for a new president to fix those kinds of problems, frankly. So I already mentioned the taxpayer identification number for the estate can be obtained at the IRS's website. And you need that for an estate administration if somebody passes away, and for a trust administration if somebody passes away. I guess we have the option to pause for a break if you'd like, or if you want me to go straight through and finish a little earlier, I can do that too. I'm flexible either way. So I'll just take a vote by poll. Would you like me to go straight through? Raise your hand. Anybody who wants a break? You know, if you want to take a break, the majority wants to go straight through, but if you need to leave and come back, you just go right ahead. I have a 7-year-old. I'm used to being interrupted, bling on my work. So there was the story of the elderly woman who was called to jury duty, and she was asked during voir dire if she'd ever had to deal with an attorney, and she said, yes, I hired a lawyer to prepare a will for me. And he asked, so how did that go? And she said, I don't know, I guess we'll find out when I die. And it's pretty true. The documents that we prepare in estate planning, hopefully they stand the test of time, meaning the circumstances that change in the client's life, or if they don't, one hopes the client comes back and fixes those, but until a person passes away, we don't know. Sometimes it's important to name contingent people as the personal representative or the executor, because a lot of people sort of have this, well, I have a will, check, I'm done, I don't ever have to go do that again. And so if they've named a person as their personal representative or their spouse and then a person, sometimes they don't look to see if that person predeceased them. They don't even remember that that's who they named as their alternate. So sometimes it doesn't, even though you have a document, sometimes it didn't stand the test of time, and sometimes it does. But in the cases where things don't go so smoothly, we have to go back to the state statute to address how those things have to work and who we have to give notice to and that sort of thing. So again, the notices to the heirs and the devisees is your first step of the administration. The next step is you're required as the attorney to assist the personal representative in preparing an inventory, which is essentially a list of the assets of the estate. Now, in many cases, I will also, those are the only pieces of information that we're required by law to give to all of the beneficiaries is the assets of the estate. And when I say estate for probate purposes, it's a little bit different than estate for tax purposes. But for the probate court's purposes, the estate is the stuff that's solely in my name when I die with no beneficiary, okay? No joint owner. So the probate estate is a little bit different than the taxable estate. The personal representative has to get a good idea of the whole value of everything when I die, not just my probate estate, but they're only required to give my beneficiaries of my will the inventory of my probate estate. Does that make sense? So my probate estate inventory has just the assets that I owned when I died with no joint owner, no beneficiary, and we have to put a date of death value on those assets. We can file them at the courthouse. We're supposed to have a preliminary one done around 6 months, but we have to have one by 9 months of some sort. And it must be made available to the beneficiaries. Usually, unless a beneficiary demands that it be filed, I try to see if they are willing to waive the filing of the inventory at the courthouse, because we want to keep that information private if possible. We call it CNN, the Courthouse News Network. As soon as you file a probate, in the small towns, people are kind of waiting because they want to know what that person had when they died and who's going to get it. So it's great coffee shop talk, sorry. So we try to keep that stuff private if we possibly can. Sometimes when we file it, we will request it be sealed so that it can't be observed by people other than the heirs, or persons who have an interest, like creditors, can see it. If a person requests a copy and they can show they have an interest in the estate, it has to be made available to them. The personal representative must take possession of or control of the decedent's property, and the title vests immediately in the heirs or the beneficiaries. It vests, but it is subject to the administration proceeding. So in other words, so if I pass away and my kid is the specific bequest beneficiary of a piece of land, and the rest of my will says everything else after payment of expenses goes equally, well, there's a time frame where we have to find out what I owe and what I own. And if what I owe is more than the everything to everybody else part of the will after expenses, it's possible that the kid who's getting the specific bequest won't get it free and clear. So even though it vests, meaning all he had to do was be alive when I died in order to be entitled to that piece of property, he may not get it if there are creditor claims, or maybe I was involved in a car accident and I got sued right before I died, and there is a claim against the estate that could divest it of the estate and therefore of that beneficiary. The personal representative have really broad powers to deal with all of these things like paying creditors off, negotiating settlements with creditors. This happens a lot. Somebody owes credit card debt, and the personal representative will call and negotiate with credit card companies to see if they'll take a little bit less rather than their full payment, especially if we have a low cash value estate. And they can do that without having the court approve it first. Sometimes we have the court approve it first just to make sure that no creditor claims that somebody was given preferred treatment. But they have the power to do all of those things, or go in and ask the court, please give me direction on this issue. The attorneys or the personal representative will take various roles, and you'll find that you have some clients that kind of go out there and they hire the appraisal and take the appraiser out there and have them look at the property and write the report. Sometimes they will go around and get all the date of death values from the banks and other places rather than having us send the letters asking for that information. Sometimes they'll just go ahead and sell the car and tell us what they sold it for. And so sometimes the personal representative takes a very active role. Sometimes they come in with boxes of stuff and dump it on your floor and say, tell me what there is. And then we dig in. So you will find that it just depends on the client and their sophistication or their time, what they have time to deal with, or their patience, or how crazy the issues are in the probate administration. But in some cases, you will have to get a third-party opinion of value. Land is a good example. Closely held business stocks, so if I pass away, somebody's going to have to put a value on my ownership of the law firm if there isn't already a contract in place with the firm saying what is the value if I die. The date of death balance of bank accounts, investment accounts, looking at the decedent's most recent income tax return will a lot of times help you find the information about what they owned, because they may be getting a 1099 from an account showing that they're getting an interest distribution every year, and you may not otherwise know much about that. Sometimes we will actually pretty much make the personal representative come in and we will supervise their writing of the checks or their deposit of things into the account, because in the end there has to be a report to the beneficiaries showing the income that was paid in and the expenses that were paid out. And some personal representatives do a really great job of recording that information. So like they'll make a deposit and they'll write down what the deposit was. So it would be cash found in mom's sock drawer of $60.43, you know, and a refund from Wellmark, Blue Cross Blue Shield, and from the Daily Republic newspaper, and they will itemize them, and then when they take in the deposit, you know what it is. Sometimes you have no idea what this is, and so you have to go back and try to figure that out. And so if we have people that aren't very good at that, then we have to help them. And I usually do a really thorough explanation to the personal representative saying, if somebody has a question because they can't tell what this deposit was when we type this up, or they can't determine what you wrote that check for, or if there was cash withdrawn from the account and you can't explain what the cash was spent for, then the judge will be asking you to explain it to them in court. So please keep good records. So we will a lot of times do that coaching. In the case where you have siblings and they're all kind of involved in settling the affairs, and the oldest sibling, let's just say, is the personal representative and has paid everything and made the deposits and gives them a copy of the handwritten checkbook ledger or prints it off the online account statement, and they all look at it and say, it looks great to us, it's not a very large estate. They might waive of formal accounting of any kind and agree to close the estate based on that. Otherwise, we have to prepare it. Seldom do we find that people want it to be reported to the court so they can come in and object, but that can happen. Okay, this is the fun part, the tax stuff. The filing of the tax return. Oh, I guess I don't get to that really quickly here. Sorry. Okay. I guess I reference it here. You'll have to prepare an estate tax return or an income tax return, or an accountant will do these things. I don't do income tax returns. The accountant always does that in estates that I work with. I do estate tax returns though. Okay, creditors or notice in general. If we aren't sure that there might be other people who claim to be an heir of the decedent, he may or may not have had kids other than the one that showed up. We might publish notice in the paper to make sure that nobody else shows up claiming to be a kid. We did have that happen once. Somebody showed up from Texas and said, my kid is a kid, and we're going to do a blood test with the decedent's identical twin brother, and we'll let you know. And lo and behold, the family didn't know that this 14-year-old was their grandson/nephew. So that happens sometimes. So publishing notice sometimes is a good idea if you're maybe not sure the person didn't live here a long time. Publishing notice to creditors is a great idea when you're not sure what the person's creditors' claims might be, especially if they're in their haymaking years, so to speak. If they have a Main Street business or they're farming, we don't know who they hired to fix fence and still owe money to type thing. So publishing notice in the local paper requires that creditors, unless they're known to us, if there's an IRS tax lien that's been filed, we can't just publish notice and go, whoops, sorry IRS, I didn't know you were a creditor. But if it's an unknown creditor, they are required to file their claim within, brain dead, 60 days of the mailed notice to the creditor. If you mail the creditor a notice and say you got to file a claim, it's within 60 days of the mailed notice. If it is a published creditor claim, they have 4 months from the date of the first published notice of the newspaper. And once those timeframes are final, if they haven't filed a claim, they're barred unless they can show that they were known, like there's a mortgage against the house. Well, gosh, I mean, that's probably known kind of thing to the estate. If there is, oh, there it is, 4 months of first publication. I even had it written down and I had to go straight from memory. If there is no publication, the creditors have 3 years after the person's death to make a claim. So it holds it open quite some time. And if the personal representative closes and distributes assets, they could be personally liable for that claim if they haven't taken steps to bar those claims, and then the creditor shows up later and proves up their claim. So it's a protection for the personal representative. But I will say this is a difference from the old law. The old law, we had requirements for publication. The new law, the personal representative can choose. So if I'm in the long-term care facility for years before I pass away and I don't have anything, and the only creditor is the nursing home, and we know that, and the funeral home, and they know that, they've been paying my bills, they probably aren't going to pay to publish notice. The personal representative does not have to wait the statutory time frame that the estate has to stay open in order to distribute. So let me say that differently because I kind of said that backwards. The estate has to stay open for 4 months after the personal representative has been appointed, for obvious reasons, so creditors can find the estate. But the personal representative can distribute assets before that. So if it's a $5 billion estate and there are really no creditors that we know of, they might keep some cash just in case somebody shows up. But if it's all in CDs, they might just cash it all out and keep a little bit just in case. We have to follow either the will when we make distributions or the rules of intestate succession, which is the will that the state of South Dakota has for them. Disclaimers. I need to visit a little bit on this issue. If I am going to inherit something from somebody, my uncle passes away and he leaves a lot of money to me, but let's just say I'm really fortunate and I already have enough assets that someday my estate is going to be taxable. Gosh, I may not want to inherit that because then it's just going to be taxed when I die because I already have a taxable estate. I might decide to give it up. Please don't give it to me, and I will file within 9 months of the uncle's death a disclaimer saying, don't give it to me, bounce it back to the person who is leaving it to me. And then we go to their will to say who would get it if I were already deceased. It treats it as if I predeceased them. So we would look in their will to say who gets it if I had already died. So I probably am not going to file that disclaimer until I know who's going to get it. I mean, I want to see that will so I know that it's my kids, not maybe my longtime archenemy cousin or something, you know. So we have to be careful about that because sometimes there are unexpected results if people do not realize who the alternate is. But it can be, we can use life insurance too. So if I'm the beneficiary of life insurance, I can disclaim that, and if there's an alternate beneficiary, they can receive it instead of me. I can use that for a joint account or a pay on death account, and whoever the alternate beneficiary is, they would receive it. If there is no alternate beneficiary of an account or a life insurance policy, then the alternate defaults to the decedent's estate. So again, my great uncle leaves me $1 million of life insurance. I disclaim it because I don't want it to be taxable in my estate, but then we find out there's no alternate beneficiary. Well, it defaults to go to his estate, so whoever the beneficiaries under his will are would then get it.
Is it correct though that you can't disclaim if you owe like a Medicaid lien or
Yeah, I mean, you got to be a little bit careful about, well, a couple things. So first of all, if I've already accepted benefits from that asset, I can't disclaim it. It's already mine. So if it's a piece of land and I already collected rent, I can't disclaim it. If it's a CD and I already got interest payment out of it, or it was already paid to me, I can't disclaim it. But the other issue is, and if it's past 9 months, I can't disclaim it. If I do, it's treated as if I made a gift to that person that then gets it. But the issue can be, let's say I'm in a nursing home and the government is paying for me because now I have spent everything I have towards my own care, and all of a sudden now I have a great uncle that leaves me $5 million in life insurance. Well, theoretically, I can't disclaim all of it because the government is owed money. But you know, if I'm 99 and a half and my health is poor, they might not need to keep 5 million either. They might be able to disclaim 4 million and keep $1 million because that probably is enough to take care of me for the next period of my lifetime. You see what I'm saying? So, but theoretically, if it's $100,000 cash and I already owe the state of South Dakota $80,000 for 1 year's care in a nursing home, then I can't disclaim that because the disclaimer, particularly since I probably have no capacity to sign that on my own, my guardian or my personal or my power of attorney has to sign that disclaimer in a fashion that's in my best interest. And the problem is it in my best interest to give up an asset when I need to pay for my care? So I always say it's a little bit it's a little bit too black and white to say I can never disclaim if I already owe the state of South Dakota. I might be able to, depending on what the value of what I'm inheriting is. If it's way more than what I might ever need to pay my way, probably I can disclaim. Family distribution agreements. Okay, these are cool, but everybody has to agree. So sometimes the way the person's will reads doesn't make sense based on the family circumstances at the time. And the whole family agrees that this isn't really how it should be. It really should be this person gets this piece of land, this person gets, you know, there should be a different distribution pattern than what's in the will, or there's a fight and everybody's squabbling and arguing, and maybe or maybe not somebody would win a claim that there was undue influence. In those particular cases, the family might reach an agreement as to how to distribute the assets of the estate. State law permits them to all reach that agreement and to allow the court to order that that be the distribution. When you distribute the estate, if it's land, it's a deed that the personal representative signs to distribute it. Personal property could be a bill of sale, particularly if it's untitled, or if it's a stock certificate, it would be an assignment or actually signing the back, transferring it, or a check if it's cash. Closing an estate, the personal representative can close the estate informally unless it's being supervised by the judge, meaning the judge is approving everything the personal representative is doing, which is rare. if you do it informally, which by the way I hardly ever do, but if you do it informally, it's just a sworn verified statement that's filed with the clerk saying it's, you know, I'm pretty much done with everything, and then within a year of the filing of the verified statement, the probate just terminates. Typically, I like to petition the court for an order that formally closes the estate because I want to release the personal representative so that there can't all of a sudden spring up a claim without them having to get reappointed. So typically that's my preference, but there are a lot of other attorneys that feel differently about that. They prefer to just allow there to be a verified statement and let it close. However, in the order that I prepare for the court to sign when the estate is closed, we typically have, if possible, all the beneficiaries waive notice and hearing saying, yes, we agree that the court can enter this order and we don't have to show up and you don't have to give us notice, go ahead and sign the order. But in the order, I like to put in the types of powers that the personal representative still has authority to do even after the closing, like distribute an after acquired asset or file a final income tax return, that sort of thing. Some people feel like you should just leave estates open because then the personal representative, if there is a later asset, they can sign a deed and distribute it, etc. And then you don't have to start a new probate administration proceeding. Got to weigh that out and decide how you want to do that. Yeah, taxes. Whew. Okay, so this is the crazy thing. I really start to feel old when I talk about taxes. Taxes have changed dramatically. The federal state tax rules have changed dramatically over the years. So I will do my best to kind of walk you through this basically. So the way it works is I can pass unlimited amounts to charity, unlimited, and there's no tax. I can pass unlimited amounts to my spouse, and there's no tax. However, if I either gift during my lifetime or transfer at death more than $5 million, and it's indexed for inflation, so as of this year it's $5.45 million, then there is a tax on the excess value of that, with the exception that I can give $14,000 per person per year. So I'm going to back up again and say it in a different way. So I can give, if I had the money, each of you $14,000 today, this year, and I don't have to file a gift tax return as long as that's easy to value. So if it's cash, I can give you each $14,000. The IRS just doesn't care because it's not more than $14,000 per person. Okay? And that doesn't come off my pot of $5 million. I still have the 5.45 over here to use up to give away. But if I gave two people $114,000 and everybody else $14,000, I would have to file a gift tax return and say, dear IRS, I gave away $200,000 more than my 14 per person, and I have used up some of my pot of 5.45. I now have 5.25 left to give away either while I'm alive or someday when I die. Okay? Does that make sense? Okay. My spouse can also give away 5.45 and $14,000 per person per year. Right? Okay. Here's the dilemma. Let's pretend my spouse and I each own a half interest in $6 million worth of land, joint with right of survivorship. So we've got these pieces of land. If I die, he owns it all. If he dies, I own it all. As I stand here today, I own $3 million, and my spouse owns $3 million because we each have every other teaspoonful. I have half, he has half. And if I want to, I can deed my half to anybody I want to. Nothing you can do about that, except I probably wouldn't go home and sleep again. So I can gift my $3 million to anybody I want to during my lifetime. If I don't, when I die, it transfers to him because he's the surviving owner, right? Okay. So I pass away, and he now owns $6 million worth of land. His own $3 million plus the $3 he inherited from me. Problem is, he has a $5.45 million exemption and $6 million worth of land, right? Oops. So the problem is that even though collectively we have $10 million indexed for inflation, it's not an automatic thing that just because I have 5.45 and he has 5.45, that he just automatically has mine if I die. The process is he has 9 months from the day that I die to say, dear IRS, Trudy had a 5.45 million exemption. She didn't use any of it by making lifetime gifts. And I want it because everything she had when she died came to me, and she didn't use any of it giving assets to somebody else. Okay, so again, he gets my $3 million, so now he has 6. He files a death tax return saying Trudy had $3 million worth of land and a $5.45 million exemption. I want the exemption because I got the land. So now he has $6 million worth of land and a $10.9 million exemption, his plus mine, right? Okay, different scenario. Let's say instead of giving my $3 million to him, I do a deed and I transfer it to my kid right before I died. So now my husband has $3 million worth of land and a $5.45 million exemption. I had a $5.45 million exemption, but just before I died, I burned up $3 million of it, right? So there will have to be a gift tax return filed as of the year I died because I gifted it to somebody besides my spouse. But I still have 2.45 left of my exemption. My spouse can still file a death tax return saying, dear IRS, Trudy died. She used up $3 million of her exemption, but there's still 2.45 left. I want it. And if he asks for it within 9 months, they have to give it to him. So now he has $7.9 million of an exemption to protect his $3 million worth of land from tax. And depending on what else he has, if he has cash or livestock or equipment or life insurance or something like that, he might need all of that exemption to protect his assets from tax when he passes away. Because the wicked thing is, if those assets exceed his exemption, the tax is a 40% rate, which is a big ouch. Again, I can give unlimited amounts to charity, unlimited amounts to my spouse. If I give more than $14,000 per year to somebody, then it uses up my pot, and I have to file a gift tax return, and now I have less to give away when I die. If my assets, when I die, exceed 5.45 million or are really close, even if it's all going to charity or it's all going to my spouse, the personal representative is required to file a federal estate tax return. And remember, when I say all assets, now this isn't just my probate estate. Remember, probate is just the assets solely in my name with no beneficiary or no pay on death. This is all assets. So if I own life insurance that pays when I die, if I have a retirement account, if I have joint assets with somebody, all of those things are taxable transfers, and the value of those have to be put on a federal estate tax return. Now, it might be going to a person who doesn't pay tax, like my spouse, or to a charity, but it's still a taxable transfer because now I've exceeded my exemption amount. When we file that federal estate tax return, we have to consider past gifts. We have to consider transfers of land to my kids where I've retained the life estate. We have to consider life insurance that I owned but changed ownership to somebody else within 3 years of the day that I died. All those come back on my federal estate tax return. Special rules. So in the example of the joint land, joint with the right of survivorship, my spouse and I, let's say we have a joint account. Typically, only half of that value of that joint account is going to be treated as mine, transferring to my spouse. But if we can show that all of that cash was mine and it wasn't contributed to by somebody else, then the whole value of that account. So usually with spouses, it's half and half usually. That's how it's done most of the time. But let's say it's my account and I have my child on it as a joint owner, mainly because I just want them to have that account when I pass away, but I put all the money in, then the whole value of that account is on my estate tax return, not just half of it. Okay. One thing I want to be really careful about and make sure that everyone understands, it's really hard sometimes to tell a personal representative we need to know the value of everything, because they'll think that I need to know the value of the life insurance or I need to know the value of the retirement account because somehow I'm going to get a fee out of that. You see what I'm saying? So we have to be really clear with them to explain we need to know the value because we need to be sure we don't have, you as the personal representative, don't have to file a tax return. And sometimes even when there's no probate estate administration, we have to file a death tax return and we have to collect values of all these assets. There is also a new basis reporting requirement for any personal representative or person who has to file the federal estate tax return. They have to show that they gave the heir or beneficiary the new tax basis in the property. In other words, the date of death value of that asset that they're inheriting. So it's important that we explain to the personal representative or the surviving spouse, if they inherit everything as the joint tenant, why these asset values are important, why we have to look this information up, even if it's just going to them as a spouse for life insurance purposes. And then also, it's important that we know this because we will be potentially doing some additional planning with that spouse to say, are you going to have a taxable estate? Do you need to start making gifts to your family? In some cases, in some communities, it's traditional that the accountants prepare the federal estate tax returns as well as the income tax returns. In some communities, the attorneys do those, just letting you know. They're due 9 months from date of death. If you can't file it within 9 months because you're still missing values, you can ask for an extension. They'll give you an automatic 6-month extension, but they won't give it to you if you miss your 9-month deadline necessarily. You have to, it's a big act of Congress almost to get an extension if you miss your 9-month deadline to ask for the extension. You don't get an extension on the tax. If you owe tax, you have to pay it 9 months, even if you can extend your tax return filing, so you at least have to estimate what the tax is. Assets that are not easy to value, like land, you probably need an appraisal. Equipment, you might need a local dealer, John Deere dealer, to give you a value of those assets, or an auction barn, auctioneer might give you an opinion on cattle, that sort of thing. Every life insurance policy that pays on death, you have to write to the company and ask for what's called a Form 712. It shows who the owner is, who the beneficiaries were, and what the value was, and whether the ownership was transferred at all during the term of the policy. You have to attach your appraisals, the certified copy of the will, the certified copy of the death certificate, certified copies of any trusts, and gift tax returns. I mentioned this before, we don't have inheritance tax or estate tax in South Dakota, but other states near to us do. Minnesota does, Iowa does, Nebraska does. Trust income tax returns. Income tax returns for trusts must be filed if there's more than $600 of taxable income, but the rates, once you hit like, I want to say 13,000, income tax on income that is kept in a trust or estate that's not distributed within that year of death is high, like 39%. So you want to be sure that if there are distributions made, you try to make that distribution of at least the income within a year of the decedent's death, or I think you get a 4-month grace period after that year end. If there's no federal estate tax return due, then a lot of the expenses are deducted on the estate's income tax return. But if you have a federal estate tax return, you might want to be, and there's a tax due, you're going to want to deduct those against the estate tax because those tax rates are high. Okay, couple of things to keep in mind, and I'm going fast on this because I want to talk just really briefly about the problems. Be careful about who your client is. the personal representative owes duties to the beneficiaries. And while the personal representative is typically your client because they owe duties to the beneficiaries, it's really important that we make sure that if the personal representative wants to have a transaction with the estate, lease land, purchase land, or that sort of thing, and it's not specified in the document, you're going to want to get all the beneficiaries to agree, or you're going to want the court to approve it, because otherwise there's a conflict of interest. And you have to be really careful, and you may end up having to withdraw as the attorney for a personal representative if they're doing improper things. Because even though they're your client, you do have these duties through them to the beneficiaries. Okay, fees. I will tell you, in our part of the world, typically fees are hourly rate. The old probate code said that the attorney fee was essentially 3% of the assets of the estate and 1.5% of joint assets. The new probate code just says the fee for attorneys must be reasonable. If you're charging based on the assets of the estate, the client will probably go elsewhere because it's not a very competitive fee. And in our area, at least, there are probably other areas of South Dakota where that might still be a competitive fee, but it's not where I am. Typically, they're hourly rates or flat fees based on how many hours the attorney estimates that they will put in, or some combination of thereof. Fees should and will be adjusted by a court if they're too high, and we generally ask the court to approve our fees in the final order of complete settlement. If it's simple, if it's just cash and we're charging based on the value of the assets, the court will most likely, if it's a high value asset, reduce our fee. On the other hand, if it's an insolvent estate and there's a ton of work but very little value and we're trying to sort it out amongst the creditors, hourly rates are totally appropriate, and the court probably won't reduce it if you really show that you did the work, because it is a lot of work in those cases and not always that much fun. Make sure that the fee is in writing, because otherwise by the time that the fee is paid, there's sometimes misunderstanding. Make sure you specify which costs that the estate is going to pay, and you can choose in your written fee agreement whether you want to wait till the end to take your fee or get installment payments on that. We typically, I'm lucky I'm in a firm, so I don't have to necessarily take fee on an installment basis to pay my overhead periodically. The more established you are, the easier it is to take the fee at the end, and it's easier for me to take the fee at the end because the court's approved it before I get paid. But that's not always feasible, especially if you're in a small area practice. Okay, quickly, and I'm hanging around afterwards for a little bit if you have questions. I just want to show you when you get to the problems. First of all, one thing that I think people had a little bit of trouble with last year is which documents to use. Remember, again, use the chart. If there is a joint owner, or if there is a transfer on death beneficiary, then you don't need to do a probate. If it's land, even if the value is small, there has to be a probate if there's not another owner. If it's a cash or other type of account and the value is less than $50,000, you can use the affidavit of small estates instead of a probate. Otherwise, use that chart. I think that will be really helpful. The other thing that I think is really important for you to noodle through is the tax issues. So if all the assets are going to a person that is not going to pay tax, a spouse or a charity, even if they're not going to pay tax, if the total estate is $5,450,000, there will be a federal estate tax return. Okay? If it isn't a $5 million estate or even close, you may, in your answer, want to advise the personal representative, if it's the spouse, to file a federal estate tax return anyway to transfer the unused exemption of the deceased spouse, because then the surviving spouse has extra cushion of exemption for someday in the future when they pass away for the assets they have. So you may, in your answer, want to include a recommendation that the personal representative consider filing a federal estate tax return to transfer the exemption to the spouse. And I will just tell you, I always give the spouse the choice, but just rule of thumb, you can stick your finger in the wind and try to measure it somewhere. Generally speaking, if the surviving spouse has $3 or $4 million in assets of their own, I almost always tell them you should strongly consider filing a federal estate tax return and transferring your spouse's unused exemption. Or if they have $2 million of their own and they're inheriting $2 million, they should consider transferring the unused exemption, particularly if they're young, because especially if it's land, that could easily double or triple during their lifetime. And the growth of that asset might be on a slope like this, whereas the exemption is on a slope that's like this, and it will eventually blow past their exemption. So land assets appreciate generally over time, potentially faster than the exemption will appreciate. So it's always an important discussion to have and let them make the choice.
And we will be talking to you via phone tomorrow, so for students that have questions, we'll be able to ask you more about the assignment then.
Great.
So thank you so much for coming, and we appreciate it.
Yeah.
It was a pleasure. Thank you very much.